Chapter 4. The Lawyer's Duties to the Legal Profession. A. Upholding integrity of profession. Canon 7. A lawyer shall at all times uphold the integrity and dignity of the legal profession and support the activities of the integrated bar. Rule 7.01. A lawyer shall be answerable for knowingly making a false statement or suppressing a material fact in connection with his application for admission to the bar. Rule 7.02. A lawyer shall not support the application for admission to the bar of any person known by him to be unqualified in respect to character, education, or other relevant attribute. Rule 7.03. A lawyer shall not engage in conduct that adversely reflects on his fitness to practice law, nor shall he, whether in public or private life, behave in a scandalous manner to the discredit of the legal profession. 1. Generally, Canon 7. A lawyer shall at all times uphold the integrity and dignity of the legal profession and support the activities of the integrated bar. Maintenance of a high standard of legal proficiency and fair dealing is a prerequisite to making the bar an effective instrument in the proper administration of justice. It is necessary that lawyers strive to uphold the honor and maintain dignity of the profession and to improve the law and the administration of justice. The respect of the public to the legal profession is enhanced by the faithful performance of the lawyer's duties to the court, to society, to his brethren in the profession, and to his clients. Such respect is diminished whenever a member betrays the trust and confidence reposed in him by his client. Public confidence in law and lawyers may be eroded by the irresponsible and improper conduct of a member of the bar. Thus, every lawyer should act in a manner that would promote public confidence in the integrity of the profession. A lawyer should also involve in and actively support the activities of the IBP. 2. A person shall make no false statement in his application for admission to the bar. Rule 7.01. A lawyer shall be answerable for knowingly making a false statement or suppressing a material fact in connection with his application for admission to the bar. Observance of the duties and responsibilities of a lawyer begins even as a law student. A student's failure to live up to them may be a ground for SE to refuse admission to practice or for disbarment should SE learn later on about his or her transgressions. A person seeking to be admitted to the bar must show that he has all the qualifications and none of the disqualifications prescribed by law. 3. A lawyer shall not support unqualified applicant to the bar. Rule 7.02. A lawyer shall not support the application for admission to the bar of any person known by him to be unqualified in respect to character, education, or other relevant attribute. A lawyer should not readily execute an affidavit of good moral character in favor of an applicant who has not lived up to the standards set by law. He should volunteer information or cooperate in any investigation concerning alleged anomaly in the bar examination. This is to help guard the profession from candidates who are unfit or unqualified. He should expose without fear or favor before the SE corrupt or dishonest conduct in the profession and should not hesitate to accept professional employment against a lawyer who has wronged his client. 4. A lawyer shall always conduct himself ethically and morally. The best way a lawyer can uphold the integrity and dignity of the profession is not to engage in conduct that adversely reflects on his fitness to practice law, nor shall he, whether in public or private life, behave in a scandalous manner to the discredit of the legal profession. Rule 7.03. He should endeavor to conduct himself in such a way as to give credit to the legal profession and to inspire the confidence, respect, and trust of his clients and the community. Acts which adversely reflect on the lawyer's fitness to practice law, which justify suspension. 1. Gross immorality. 2. Conviction of a crime involving moral turpitude. 3. Fraudulent transactions. 5. gross immorality reflective of unfitness to practice acts of personal immorality in his private relation with the opposite sex. Gross immorality of the act, not merely immorality, to justify suspension or disbarment. Grossly immoral act 1. One that is so corrupt and false as to constitute a criminal act 2. Unprincipled or disgraceful as to be reprehensible to a high degree. Acts of gross immorality, justifying denial of application to take the lawyer's oath or suspension or disbarment. 1. Living an adulterous life with a married woman. 2. Maintaining illicit relations with a niece. 3. Abandonment of his lawful wife to live with another woman. 4. Contracting marriage while first marriage still subsisting. 5. Seducing a woman to have carnal knowledge with her on the basis of misrepresentation that he is going to marry her, that he is single, or that they are already married upon signing a mere application for marriage license. 6. Carnal knowledge with a student by taking advantage of his position. However, mere intimacy between man and woman, either of whom possess no legal impediment to marry, voluntarily carried on and devoid of any deceit on the part of the lawyer, is not corrupt or unprincipled to warrant disciplinary action as member of the bar, even if the relationship results in the woman giving birth to a child, so long as he admits paternity and agrees to support the child. Cohabitation per se is not grossly immoral. Whether a liar's sexual congress with a woman not his wife should be characterized as grossly immoral will depend upon the surrounding circumstances, even if the evidence is not sufficient to hold a lawyer liable for gross immorality. May nonetheless be reprimanded where such evidence shows failure on his part to comply with the rigorous standards of conduct. 6. Conviction of a crime involving moral turpitude. Moral turpitude. Anything which is done contrary to justice, honesty, modesty, or good morals. Any act of vileness, baseness, or depravity in the private and social duties a man owes his fellow men or to society, contrary to the accepted rule of right and duty between man and woman. In general, all crimes which fraud or deceit is an element. Lawyers convicted of such crime are either suspended or disbarred. 7. Commission of fraud or falsehood. Commission of such may badly reflect on his fitness to practice law. He may be administratively disciplined. Acts of misconduct calling for disciplinary actions. 1. Falsely stating in a deed of sale that the property is free from liens or encumbrances. 2. Knowingly taking part in a false and simulated transaction. 3. Making it appear that a vendor, long dead, executed a document of sale in his favor. 4. Concealing in an information sheet required by law in connection with his employment the fact that he was charged with or convicted of a crime. 5. Borrowing money as a guardian for his benefit upon the ward's property as collateral without the court's approval. 6. Encashing a check payable to his deceased cousin by signing the latter's name. 7. Falsifying a power of attorney and using it to collect the money due the principal and converting it to his benefit. 8. Misappropriating money belonging to his employer. B. Lawyer's relation with other lawyers. Canon 8. A lawyer shall conduct himself with courtesy, fairness, and candor toward his professional colleagues, and shall avoid harassing tactics against opposing counsel. Rule 8.01. A lawyer shall not, in professional dealings, use language which is abusive, offensive, or otherwise improper. Rule 8.02. A lawyer shall not, directly or indirectly, encroach upon the professional employment of another lawyer. However, it is the right of any lawyer, without fear or favor, to give proper advice and assistance to those seeking relief against unfaithful or neglectful counsel. 1. Generally, membership in the bar imposes upon lawyers certain obligations to one another. What makes the practice of law a profession: observance of honorable, candid, and courteous dealings with other lawyers, fidelity to known and recognized customs and practices of the bar. 2. Candor, fairness and truthfulness should characterize relations. The court reminds parties and counsels to avoid further squabbles and unnecessary filing of administrative cases against each other. Mutual bickering and unjustified recriminations between attorneys detract from the dignity of the legal profession and will not receive sympathy from the court. Duty of lawyer to restrain his client from improprieties and to terminate his relation with him if the latter persists in his wrongdoing. A lawyer should not use, to his or his client's benefit, the secrets of the adverse party acquired through design or inadvertence. A lawyer who thinks a case is weak may not criticize the lawyer who accepts it. Much less should he attribute to him evil motive for taking up the client's cause. It is not, however, improper for a lawyer to accept employment to compel another lawyer to honor the just claim of a layman. His action towards such end, as writing a letter of demand to the lawyer, is not unethical since it is mere honest effort to serve the interest of the client. 3. A lawyer should use temperate language. Rule 8.01. A lawyer shall not, in professional dealings, use language which is abusive, offensive, or otherwise improper. His arguments, written or oral, should be gracious to both the court and the opposing counsel, should be of such words as may be properly addressed by one gentleman to another. Do as adversaries do in law. Strive mightily, but eat and drink as friends, whichever may be the ill feelings between the clients should not influence counsel in their conduct and demeanor toward each other. They should scrupulously avoid all personalities and personal history or personal peculiarities and idiosyncrasies of the other. 4. A lawyer shall not encroach upon business of another. Rule 8.02. A lawyer shall not, directly or indirectly, encroach upon the professional employment of another lawyer. However, it is the right of any lawyer, without fear or favor, to give proper advice and assistance to those seeking relief against unfaithful or neglectful counsel. A lawyer should not steal the other lawyer's client nor induce the latter to retain him by promise of better service, good result, or reduced fees for his services. Neither should he disparage another, make comparisons, or publicize his talent as a means to further his law practice. It is, however, the right of a lawyer, without fear or favor, to give proper advice to those seeking relief against unfaithful or neglectful counsel. He may accept employment to handle a matter previously handled by another lawyer, provided that the other lawyer has been given notice of termination of service. Without such notice, he shall only appear once he has obtained conformity or has, at the very least, given sufficient notice of contemplated substitution. A lawyer's appearance in the case without notice to the first lawyer amounts to an improper encroachment upon the professional employment of the original counsel. 5. Negotiation with opposite party. Canon 9 of the Canons of Professional Ethics provides that a lawyer shall not in any way communicate upon the subject of controversy with a party represented by counsel. Much less should he undertake to negotiate or compromise the matter with him, but should deal only with his counsel. It is incumbent upon the lawyer most particularly to avoid everything that may tend to mislead a party not represented by counsel, and he should not undertake to advise him as to the law. A lawyer should not, in the absence of the adverse party's counsel, interview the adverse party and question him as to the facts of the case, even if the adverse party was willing to do so. Neither should he sanction the attempt of his client to settle a litigated matter with the adverse party without the consent nor knowledge of the latter's counsel. 6. Association as a colleague in a case. A client's proffer of assistance of additional counsel should not be regarded as evidence of want of confidence, but the matter should be left to the determination of the client. The second lawyer should communicate with the first before making an appearance. Should the first lawyer object, he should decline association, but if the first lawyer is relieved, he may come into the case when there is conflict of opinions between two lawyers jointly associated in a case. The client should decide The decision should be accepted unless the nature of the difference makes it impracticable for the lawyer whose judgment has been overruled to cooperate effectively. In this event, it is his/her duty to ask client to relieve him/her c. Preventing unauthorized practice of law. Canon 9. A lawyer shall not, directly or indirectly, assist in the unauthorized practice of law. Rule 9.01. A lawyer shall not delegate to any unqualified person the performance of any task which by law may only be performed by a member of the bar in good standing. Rule 9.02. A lawyer shall not divide or stipulate to divide a fee for legal services with persons not licensed to practice law, except 1. There is a pre-existing agreement with a partner or associate that, upon the latter's death, money shall be paid over a reasonable period of time to his estate or to persons specified in the agreement, or 2. Where a lawyer undertakes to complete unfinished or legal business of a deceased lawyer, or 3. Where a lawyer or law firm includes non-lawyer employees in a retirement plan, even if the plan is based in whole or in part on profit-sharing arrangement. 1. Duty to prevent unauthorized practice of law. Canon 9. A lawyer shall not, directly or indirectly, assist in the unauthorized practice of law. Public policy requires that the practice of law be limited to those individuals found duly qualified in education and character. The permissive right conferred on the lawyer is an individual and limited privilege subject to withdrawal if he fails to maintain proper standards of moral and professional conduct. Purposes to protect the public, the court, the client, and the bar from incompetence and dishonesty of those unlicensed to practice law and not subject to the disciplinary control of the court. The law makes it a misbehavior on the part of the lawyer to aid a layman in the unauthorized practice of law. A person not admitted to the bar may not hold himself out to the public as engaged in the practice of law, either alone or as associated with a practicing attorney under a firm name. U.S. v. Nay 1907. He may not form a partnership with a lay accountant to specialize in income tax work unless he ceases to hold himself out as a lawyer and strictly confine his activities to such as are open to lay accountants. 2. Intervention of intermediary not allowed. Prohibition on intermediary to intervene in the performance of lawyers' professional obligations. Lawyer's relation to client is personal and responsibility is direct. Intervention of lay agency between lawyer and the client is forbidden. It is thus improper for a lawyer to accept employment from an automobile club which, in soliciting membership, offers free services of its legal department to members. Employment should not include the rendering of legal services to members of such an organization in respect to their individual affairs. A charitable society rendering aid to the indigent is not, however, an intermediary within the meaning of the Rule 3. A lawyer shall not delegate legal work to non-lawyers. Rule 9.01. A lawyer shall not delegate to any unqualified person the performance of any task which by law may only be performed by a member of the bar in good standing. He should not delegate to a layman any work which involves the application of law, such as 1. The computation and determination of the period within which to appeal an adverse judgment. 2. Examination of witnesses. 3. Presentation of evidence. Can employ secretaries, investigators, detectives, researchers as long as they are not involved in the practice of law, e.g., not writing pleadings, appearing in court, etc. 4. A lawyer shall not divide fees with non-lawyers. Rule 9.02. A lawyer shall not divide or stipulate to divide a fee for legal services with persons not licensed to practice law. Exceptions. 1. Where there is a pre-existing agreement with a partner or associate that, upon the latter's death, money shall be paid over a reasonable period of time to his estate or to persons specified in the agreement. 2. Where a lawyer undertakes to complete unfinished or legal business of a deceased lawyer. 3. Where a lawyer or law firm includes non-lawyer employees in a retirement plan, even if the plan is based in whole or in part on profit-sharing arrangement. The first two exceptions to the rule represent compensation for legal service rendered by the deceased lawyer during his lifetime, which is paid to his estate or heirs. The third exception to the rule does not involve, strictly speaking, a division of legal fees with non-lawyer employees. The retirement benefits in the form of pension represent additional deferred wages or compensation for past services of the employees. Impropriety arises where the effect of the arrangement is to make the estate or heir a member of the partnership along with the surviving partners, or where the estate or heir is to receive a percentage of fees that may be paid from future business of the deceased lawyer's clients. Such fees no longer represent compensation for past services of the deceased lawyer. An agreement between a union lawyer and a layman president of the union to divide equally the attorney's fees that may be awarded in a labor case violates the rule.